You got it.
I think
The webinar will consist of a 40-minute presentation approximately, followed by about 10 minutes of Q&A at the end of Scott's presentation. If you would have questions at the bottom of your screen, please type in your question for us to share with the presenter, and you'll look for the Q&A box. Your question will either be answered live or addressed during the presentation, time permitting. This conversation will continue on the PQMD community of practice, so if you have any other comments, questions, or examples, please submit them to the COP online platform at cop.pqmd.org. And you can post questions and thoughts by clicking on the GDPR link on the right side of the website that has been established for the continuing dialogue on this topic. So now I hand it over to Scott and Kim. Kim Keller, if you could provide some context for this webinar and then hand it off to Scott to present.
Thanks, Veronica, and thanks, Jen. Can everybody hear me?
Yes.
Okay, my name is Veronica said is Kim Keller, and I'm the outgoing chair of the PQMD Guidelines Committee. And I'm proud to say, just first of all, that the 2018 guidelines are posted on the PQMD website, so I encourage everyone to go check them out. Secondly, I'd like to say thank you all for joining this call, which is a quite timely call. As Veronica mentioned, the European General Data Protection Requirements go in effect tomorrow. They've also been in the news a great deal lately. I mean, Mark Zuckerberg even referenced them while testifying before the British Parliament just this week. So what are the requirements included in the GDPR? I'm a US-based company, so why do I care? We are NGOs, why do we care? And how do they affect the work we do as PQMD? To answer these questions is one of the reasons we've scheduled this webinar today. And as Veronica said, we're very thankful to Rochelle and Scott from O'Melveny and Myers, with whom we have met several times in the lead up to this call. They have graciously given of their time, and we so appreciate it. Scott is amazing, and I know we'll learn a lot through this discussion. What's the expected outcome from this opportunity, and why does PQMD, specifically the Guidelines Committee, care? We want to make sure we understand the impact of this requirement, what the impact on our work is, and how the Guidelines Committee can include some of the requirements from the GDPR in the guidelines to help share that knowledge and make sure we're all being compliant. So stay tuned to more from PQMD, and now I would hand it over to Scott Pink and thank him dramatically for all the help he's given us.
Thank you, Kim and Veronica, for the introductions and the kind words, and welcome everybody. And I'm going to spend about 40 minutes trying to distill for you a regulation that's been around for a couple of years and is, almost 100 pages long. And it's stirred a lot of concern among companies and other institutions because it does require a different approach to personal data, and it potentially has extraterritorial application beyond the borders of the European Union. So you've seen a lot in the news, and what I'm going to try to do is distill for you some of the key requirements and then discuss some scenarios that I think the donation scenarios that your entities are involved in through or in connection with PQMD, and in each of those scenarios try to discuss or outline some of the applications of GDPR to those scenarios to give you some framework for what you might have to consider moving forward. So with that sort of introduction, let me sort of dive in. So the first slide is just what is GDPR? So GDPR is a regulation, so it has the force of law in the European Union. UK, as you well know, is exiting the European Union, but for the time being, and likely even after Brexit takes effect, it will follow the same principles, so you should consider the UK to be part of it. It imposed substantive new requirements in the way companies handle personal data. Typically, you had a privacy policy. You might have had, some acknowledgement of the privacy policy, but there wasn't, at least in the United States, there's not a lot of regulation on personal data other than in the certain regulated industries like the healthcare industry and financial services. But generally speaking, there weren't regulations. That's potentially changing, at least for companies that might be doing business in the European Union. As I mentioned, it can apply to companies outside the EU. What has gotten everybody's attention is that breaches can result in significant fines, and non-compliance can create some obstacles to doing business in the EU. A partner may not be willing to do business with you because you're not GDPR compliant. So I would expect that most of the entities on this call, their significant companies would have already complied with GDPR. So we're going to focus probably more on how it might be applicable in these particular scenarios. And even though the regulation was actually passed almost 2 years ago, but there was a 2-year window to come into compliance. And as is typical in these scenarios, a lot of companies or a lot of people were not really paying attention to it to just recently. But the effective date of compliance is tomorrow. So there's a lot of interest in what the EU data regulators will do once tomorrow hits and what actions they will take with respect to compliance. So, and then on the fines, they're pretty scary. They can be up to 4% of annual worldwide turnover, or 20 million euro. So there are very significant fines potentially. It's hard to know whether to what extent those kinds of fines would ever be, applied. But there is quite a bit of power vested in the data protection authorities, as well as certain individual rights that can be claims can be made by individuals related to GDPR. So there is some concern and definitely a valid justification to getting into compliance. So does it apply? So it applies to any establishment of a controller or processor in the EU. So if you are based in the EU, you have a division in the EU, you're headquartered in the EU, you're going to be subject to GDPR with respect to that entity, regardless of whether the processing takes place there. So the EU is basically saying, EU-based companies or organizations must comply with GDPR. And for all personal data they process or control. And what has created a lot of concern and interest, at least in the United States, is the GDPR also reaches beyond companies based in the EU member states. So there are ways it can apply outside of the EU. It can apply to any company or organization that processes personal data belonging to EU residents in connection with offering goods and services to individuals in the EU. And it can apply to any company that processes personal data belonging to EU residents in the course of monitoring or profiling those residents. So that is what has created the issue in the United States, is that companies that are offering products and services to the EU, even if they're not based there, may have to, or likely have to, comply with the GDPR requirements as it relates to the data of EU residents. So that's the extraterritorial application. The other way it could possibly apply, and you'll see this in the scenarios that we'll discuss in a minute, is if you are working with an organization in the EU and they are themselves processing EU data, they have certain obligations to make sure that if they transfer that data outside of the EU or to companies, third parties, they have certain obligations to the data subject to make sure that that data is properly handled. So if you are the recipient of the data, you may be sort of indirectly or maybe directly subject to certain of the GDPR requirements by contract. So those are the main ways that this could apply. So what does it actually apply to? So it applies to data controllers and processors, and I'll get to what that means in a minute, and it governs personal data. So Personal data's definition is quite broad. It's essentially the same as it was under the prior European law, which is called the Data Protection Directive. It's very broad and includes a wide range of information, really any information that can identify an individual. So the classic examples are name, identification number, information, address, and things of that nature. But it also includes a number of other things that historically may have not been considered personal data, like location data and online identifiers, IP addresses, Google IDs, geolocation data. So it's a much broader swath of data that could be subject to the protections of GDPR. So that is a significant change for data processors and controllers, that they must consider a much broader range of personal data in determining compliance. So there are two sets of parties that are subject to GDPR, and their role in connection with compliance is different depending on whether you're a controller or a processor. And GDPR broadly applies to data processing, and that is also quite broadly defined as any operation, set of operations performed on personal data, whether automated or not. So as examples, any collection, any recording, organization, structuring, storage, retrieval, or use of data falls within the ambit of processing, which is regulated by GDPR. Chances are, if you're exchanging data with another party and it's EU resident data, and you're storing it or using it for any purpose, you're likely processing it. And then, which end of the spectrum you will fall into, which category, will depend on your role in connection to the data. So the primary party, and the one with the most obligations under the GDPR, is the data controller. And the data controller is the organization that determines the purpose and means for processing of personal data. So if, for example, if you were a healthcare provider and you were collecting data on your patients for providing medical care, you are the data controller. If you are providing software services to that healthcare provider, such as electronic medical record system, and the healthcare provider provides you that data, you are the processor, because you are processing data on behalf of controllers. Now, a data controller can also be a controller and a processor at the same time. So, you can wear both hats, but most cases is a controller and then there's a processor. But in some cases, there are two controllers. Some cases there's a controller processor and a processor. So there's a variety of different situations that could arise. And the key is understand what role you're playing, so then you can assess what your obligations are. So the GDPR has, almost 80 or more articles that define the obligations of the data controllers and processors. And I'm only going to touch on some of the key ones here so you can get an understanding of the framework. So one of the key requirements in GDPR is you must have a legal basis for personal data processing. Otherwise, the processing is illegal. So GDPR does set out some of the bases under which you can legally process data. The clearest and most obvious one is consent, that the individual data subject agreed you could process the data. So you'll probably see a lot of situations where when you're filling out a form or providing data to some company or organization, that they will ask for your consent. The only downside of that basis is that GDPR makes it clear that you can withdraw consent at any time. And that can be challenging if you're the data controller, because you may need the data for other purposes. So that's number one. Number two is, very commonly, is you need the data to perform a contract. So if I enter into a contract with you for medical services or whatever, then I need the data to perform my obligations. So you don't need consent in that case. You just need to just collect the data necessary to perform your obligations. Another basis is a legitimate interest. This is kind of a broad catch-all provision, and we're not quite sure where that will end up, but is being relied upon for a variety of uses, such as marketing. So legitimate interest of the controller is another basis. When you are relying on legitimate interest, you have to weigh the interest of the controller versus the risk to the individual, risk of harm to the individual. So there's a weighing and balancing of interest there if you're relying on that you have to do. And then there's necessity for the public interest, which might, in a lot of the scenarios we're going to discuss, be the basis for which you're going to be able to process data. If you rely on consent, and you do need consent in some scenarios, GDPR does impose some obligations that consent must be given in a very specific manner. It must be freely given. It can't be like conditioned on agreeing to some other obligation or paying money or something like that. It has to be specific. You can't make a sort of very broad consent. It has to be informed and unambiguous. So, but bearing it in terms and conditions often is not going to work. So if you're relying on consent, you need to be very specific about it and direct, and that may be appropriate, and is actually something that certainly in the healthcare industry with authorization requirements, at least under HIPAA, you are specifically getting consent to uses of data in particular situations. So, a HIPAA level type authorization is maybe not quite what's required under GDPR, but certainly is going to come close to complying with GDPR. Some other requirements you must meet are transparency. So this is why you're seeing a lot of the updated privacy policies. You're probably being deluged in your inbox with notices from various companies saying, hey, we just updated our policy in light of GDPR, and we're giving much more detail on what we're doing. That's because of this requirement. And generally speaking, the data controllers must disclose certain information, such as how long you're going to keep the data, whether you're going to transfer the data internationally, what rights they have under GDPR, and probably more specific information on what data is being collected and how it's being used. So transparency is a major aspect of GDPR. The other area is data protection impact assessment. So the reason I raise that here is that this typically involves an assessment where there's a high risk of harm to individuals or privacy. You're supposed to do an assessment of the risk and how the company's personal data protection framework will be affected. So really the idea here is that GDPR wants companies to think about and specifically address risk where there's a high risk of harm to the individual. So this tends to be more applicable in situations where you're talking about sensitive data, such as medical data, or data about someone's ethnicity or political affiliation or things of that nature, which are considered special categories of data. So if you're collecting and processing that kind of data through some kind of a system, you need to consider the application of a DPIA to ensure that data is being properly handled and managed. This last one isn't probably all that relevant here, but there is a general requirement now that you implement data protection by design in any product or service that you develop. That you must consider privacy from the outset and take in consideration what kind of data you're collecting, minimizing what's the data you're collecting for the purposes of which it's needed, ensuring there's security, proper security in place for the data. So all of these things must be built into the design process, if you will. So that's something that the United States has been promoted as a good practice by the FTC and other organizations, but it has been mandated, and GDPR essentially mandates it. So, so if you're processing and transferring data between and among parties in these scenarios that we'll discuss in a moment, you need to consider what data is being sort of transmitted between the parties. And if you're collecting and processing personal data, you need to consider whether you need to keep a record of the processing. It's called an Article 30 record. An obligation of any controller or processor of personal data of EU data subjects is to keep a record of processing. And this they don't really prescribe the format other than the types of information you need to keep. They don't indicate it has to be automated or an Excel spreadsheet or anything like that. There are definitely software programs out there that will accommodate this. But the record of processing, for example, in the case of a controller, must include the name and contact details of the controller, the purposes of the processing, description of the category of data subjects and the categories of personal data, the categories of recipients to whom the personal data has been or will be disclosed, any transfers outside the EU, the time limits, essentially the retention period for the data, and a general description of your technical and organizational security measures. So you would create essentially a chart where, for let's say you're collecting data in connection with a particular disaster, you would, as part of your overall Article 30 obligations, you might designate a category of data you collect in connection with those processes, the purposes for which you do it, to whom you are transferring the data, if at all, what protections you're taking in terms of security and so forth, those categories. So that's something you need to consider if you're subject to GDPR. And then the other, I think, major issue you have to consider is if personal data is being involved in any of these sort of donation scenarios, if data is being transferred, and we've considered in these scenarios, mostly EU and EU to US. So the GDPR says you can't transfer personal data outside of the European Union unless it's to a country that the European Union deems to have the same protection or level protections as GDPR, as the European Union. And the United States is not considered one of those countries, so you need to have another basis to transfer, and that could be consent. There's these agreements that have been approved by the GDPR, which allow you to transfer it to an entity in the U.S. called standard contractual clauses. If a U.S. company or organization is Privacy Shield certificated, that's a certification you apply to the Department of Commerce. If you have that, you can receive the information and transfer it. And there are certain exceptions we'll discuss in a moment that could possibly allow transfers of data without even following these three requirements. But these are sort of the general approaches that companies will take between for covering transfers from the EU to the US. Another one that I haven't really raised here because I don't really know if any of these scenarios would pertain to it, but it's called binding corporate rules. And that would be like if you had an international organization that had an EU entity and a US entity, you can enter these things called binding corporate rules where the whole organization agrees to comply with GDPR requirements, more or less. And it gets approved by a data protection authority. Then you can transfer data within the organization. One other thing I was going to mention is that the GDPR covers certain special categories. Data have enhanced protections, and they call it special categories. I use the terminology sensitive here, but it's under GDPR. It's called special categories, and that's ethnicity, political opinion, genetics, sexual preferences, and applicable here, medical conditions. And what's significant here is if you're processing this data, you must have explicit consent from the data subject. So you need to be very detailed about getting consent and what you're going to be doing with the data and where you're going to be transferring it. One thing that you should be aware of is that, let's say you were conducting a relief sort of scenario, and you wanted to get some sort of generalized data about how effective the relief was, or something, just generally how did it go, and you can perhaps avoid a lot of the GDPR requirements by pseudonymizing it. Or this would be like de-identifying it under HIPAA. So the idea is you separate data from direct identifiers, so it can't be linked to an individual, but would allow you to more freely transfer the data between among organizations. So that's something you can consider as an alternative. You don't really need detailed data on an individual, like by name and specifically identifying. Another way to avoid a lot of these obligations is to pseudonymize it. And this is probably the biggest concern of companies right now is individual rights. So GDPR gives data subjects a variety of individual rights, and they're pretty unique. They don't exist for the most part under U.S. law. So one is, and the one that probably creates the most concern, is the right to be forgotten. It's really the right of a data subject to request that their personal data be erased. And it doesn't apply in all contexts, and it doesn't apply all the time, but it is a right that can be invoked, and so you need to be prepared if you're collecting personal data from an EU data subject, to deal with it if it is raised. And part of the challenge, of course, is trying to find the data to make sure it's properly erased. That's with companies with multiple systems and multiple jurisdictions, that can be daunting. They have a right to rectification of their data, and you have to, under certain circumstances, and you have to comply with that without undue delay. So that can be challenging, again, for the same reason as the right to be forgotten, is you have to find the data and then you have to correct it. And it also is a little bit unclear whether this is like changing my address in the profile field, or is it more generally changing, someone says, look, I didn't really have that condition. That's not correct. I didn't have that medical condition, or something's incorrect. Is it really apply to that? That's a little bit unclear. Sort of the general concept here is it should apply to sort of identifiers. So, you have the right address and the right name and social security number, those kinds of things, not sort of other characteristics. But we'll have to see how this plays out. The right to data portability is another one that is a little bit uncertain about where this might go, but it's a concept that a data subject can demand essentially a copy of their data in a structured, commonly used, and machine-readable format, and be able to take that data and, let's say from healthcare company 1 and go to healthcare company 2 with the same set of data. So it's to give the more control of the data subjects over the data that the companies or organizations are collecting. And then there's a right to object and restrict to certain kinds of processing. And, this is more likely to apply in direct marketing and profiling scenarios. So if you're doing automated decision making on somebody, like the classic example is like a bank loan, where you just apply for a bank loan, they run some kind of automated check on you and they deny you. This actually gives you a right to object to that and ask for an individual, like human decision on your, creditworthiness and eligibility for a loan. So let's talk about a few scenarios to kind of bring this down to what you folks might be running into. So with the help of Veronica and others, we've come up with a couple of scenarios to see and maybe talk about how this might apply. So the first scenario we had is an EU-based donor that donates medicine equipment that's made in Europe, and they donate it to a European-based NGO, and it's donated to a beneficiary in the EU for, say, fires in Portugal, just as an example. So everything is in the EU. So what do we have to worry about? So all the entities are subject to GDPR. They're operating in the EU. So they need to be aware of GDPR in connection with this particular arrangement. So where is this GDPR likely to really be important? So it struck me, and it could be others, but it struck us that, the two kinds of information that could be transferred, more likely than not, are contact information of persons in each organization. So they are communicating back and forth and, about these particular donations and, implementing this relief. So there's that information that's being exchanged and between the organizations. The other data that's likely or could possibly be exchanged is information relating to the actual beneficiaries. So that would be name and maybe some medical information, maybe address, location. It could be very specific information about the beneficiaries, which you might need for a variety of purposes, maybe for reporting purposes and other regulatory reasons, but nevertheless, that could be information that one entity needs to disclose, that collects and needs to maybe disclose up the chain. Sorry. Oops. Up the chain from the beneficiary, up the chain to the NGO, up the chain to the donor. So, so in looking at the information that's being possibly transferred and between among these entities, I don't think there's anything, you're not really getting anything else, but these would be the main pieces. So, what would be the basis? You need to establish a legal basis. So certainly you could argue if there is some kind of agreement between the entities, or at least an understanding, an MOU, where this particular relief effort is being controlled by. You have the performance of the contract. You can this information, certainly the contact information, and maybe other relevant information and about who's doing what, and maybe even the beneficiaries might be necessary to perform the contract. You might want, in the case of beneficiaries, if you are disclosing detailed medical information, you might want to get explicit consent because that could fall into the categories of special or sensitive data. It may or may not be unnecessary because it could also, you could also have a basis for processing as necessary for reasons of public interest, particularly in the area of public health. So if you need to get a beneficiary information because of an overall public health issue, like maybe even just the nature of the relief itself, or the fact that you're affecting the relief, might be sufficient if it's a public kind of disaster scenario. And you could argue there's a substantial public interest in doing that. So what kind of agreements do you need, or what kinds of documentation should you have in place? And I think there's no cross-border agreements required because you're not doing any transfers of data from the EU to any country outside the EU, at least not in this scenario. It would be a good idea to have agreements between the various entities where you define their roles and any data that's being processed. Each entity, provides assurance that they will have, reasonable technical and organizational measures in place to protect personal data, that they'll only use it for purposes of, designated in the agreement. And also some understanding of how the organizations would interact with respect to either a data security breach, which is where the information gets disclosed to a third party without that's not authorized to have it, and dealing with any data subject rights requests you might get. So I think it would be a good idea to have those all in place. You'll often see in data what they call data processing addendums or data processing agreements or data protection agreements between among entities that are exchanging personal data. And it would likely be important to have that in this case if you are going to be exchanging beneficiary data. You certainly would want that in place. You might also need to consider whether a DPIA is necessary because you are handling some sensitive beneficiary information. So that's another thing to consider. It may or may not be required here, but definitely something to think about as you go through the analysis. So scenario number 2 is where a U.S.-based company donates U.S. Medicine equipment manufactured in the U.S. to a U.S.-based NGO, and that is then donated to a beneficiary in Europe. And beneficiary could be a relief organization, and then I guess I'm also using it to mean the actual individuals that receive the medicine and equipment, for clarification. So in this scenario, the data, the contributions and donations are coming from the U.S. The entities, 2 of the 3 entities are in the U.S., and the third entity, if it's a relief organization, it might be a relief organization, maybe the relief organization is U.S., but at least at some point there's EU data. That is either the relief organization in Europe or the actual individuals receiving the relief. So let's talk about this. Well, the U.S. entities probably generally not subject to GDPR unless they're subject for other reasons, but at least not in the specific context of this example. Now, if they're a global organization that's selling products and services to the EU, they may be subject to GDPR for other reasons. But for this particular scenario, I'm assuming they're not doing business outside the U.S. except for this donation. And so their data and the data exchange between among themselves would not be subject to GDPR. But there is a scenario under which there may be data coming from the EU back to the U.S. entities, either in the form of contact information for the people on the ground that might be based in the EU, or the recipients of the aid. And that's the name and medical information. So if that comes back to the U.S. entity, then GDPR would likely apply to that data. So what would you need? Do you have sort of the same legal basis for collecting that data? Is performance of contract, explicit consent would be something to consider, and then public interest. And then the agreements required, I think you have the same data protection agreement, but you also might need a basis to transfer the data back to the US. Now, there is some exceptions under GDPR to transfer data from the EU to another country that could apply here, but it's probably more practical and prudent to have in place an agreement between the EU entity, or maybe express consent from the beneficiary that permits the data to be transferred to the U.S. But there is an exception, and I think it's one that I would consider. And under Article 49 of the GDPR, Section D, you can transfer data to a third country where it's necessary for important reasons of public interest. So if there was an adverse event reporting requirement relating to the administration of medicines or equipment, I think the argument, although we don't know exactly what this means yet, but I think the argument would be that is a requirement of law, is in the public interest, and therefore you may not need a standard contractual clause to cover transfer to the U.S. So you're going to have to think about in all of these scenarios what what data might have to come back to the U.S. and whether you want to rely on that exception or just paper it by having what we call standard contractual clauses in place, so you don't really have to worry about whether the exception applies, kind of belt and suspenders approach. The last scenario is the donation coming from an EU-based donor to a US-based NGO to a beneficiary in the US. So what's interesting here is the US entity, the EU entity is covered, but so they would have to process the data they get in connection with this effort in compliance with GDPR, but the US entities would not be subject to GDPR or its requirements under this scenario. You might want to have an agreement. You don't need an agreement to transfer the data out of the U.S. If it's medical information, you might need some authorizations on the HIPAA, but right now I'm only specifically referring to GDPR. So GDPR wouldn't require an agreement to transfer the data back to the EU. But the EU entity would have to treat the data in a way as if it had received the data directly from a recipient in the EU. So there's one where there might be still a good idea to have an agreement in place among the parties governing the kinds of data that's going to be transferred and how they're going to treat it. So I think I might have left about 10 minutes for questions.
Yes. So we're opening it up at this time. Thank you, Scott, first of all, for so much information, so valuable in terms of the work that we do and sort of breaking down the GDPR in accessible language with examples that I think will help folks really understand GDPR in terms of the work that they do specifically, whether NGO or corporate, because we have both on the line today. So we're opening this up for questions. Please use your Q&A button down at the bottom on the screen, and you'll see where it says mute, video, participants, and Q&A, and a chat function. So send in any questions you have. We did have some questions that were sent in advance. So I'll go ahead and start with those if they make sense. So we have one question from an NGO that asks, what should NGOs be thinking of in terms of their data gathering and transferring processes when working with European beneficiaries? And I'll make the note, I think you've answered this, but if you could just sort of give a quickie to make sure that they understood the answer.
Could you repeat that? What kind of entity?
So what should NGOs be thinking of in terms?
NGOs.
Yeah, NGOs what should they be thinking of in terms of their data gathering and in terms of their transferring processes or transferring data when working with European beneficiaries, be that an NGO that's a European recipient and or a beneficiary directly to a hospital or clinic?
Right. So the NGO needs to consider, number one, what kind of data am I collecting? And it can be not only data from an individual in an organization that might be assisting on the ground in the EU, but also the ultimate recipient. You know, what data am I collecting? That'd be number one, or am I likely to collect? Mm-hmm. Once I figure that out, do I have a basis to collect it? Do I have a need to it? Because you need to establish that I have a basis for it. I can't just be not collecting data for the sake of collecting data. You need to understand what you have. So you need to kind of identify, okay, what are the collection of data? And then I think once you have that, and you say, I have a basis to collect it, then depending on where you are based, you need to put into place an agreement. Well, it depends how you're getting the data, but if you're getting the data from an organization in the EU, you have an agreement with that organization which allows the data to be transferred to you, and also if it needs to go, from the EU to the US, you have what we call standard contractual clauses to govern that transfer, unless you want to rely on the exception that I mentioned before of public interest. I'd probably have standard contractual clauses in place because it's just, you never know how that public interest is going to be applied. So why not just have both?
Right.
Those would be the main things I would think about. And I might also consider whether at a practical level, do I need consent from the individuals whose data is being sort of transferred to me? You might want to get that, or might want to require whomever you just might want to consider that, because there is a requirement of getting explicit consent for certain special categories of data.
Okay. I do have another question that's just come in from one of our members. And it says, if an EU company donates to a US NGO who makes a donation in turn to a patient in the EU, would scenario number 1 apply?
Yeah, scenario number 1, let me just go up here again. Remind myself scenario number 1. So EU to US.
So I'll repeat the question. If an EU company,
no, I get it. The intermediary, the interim, the NGO is US. That's the only difference. It's EU-based donor, US NGO, EU beneficiary. Okay, so it'll be a little different than scenario number 1 in the sense that there is data going from the EU to the US because the US the US NGO is not in the EU. So there you would have to consider the cross-border transfer issues. So that would be that's the one thing you wouldn't have to consider in scenario number 1 that you would have to consider in that variation.
Okay. I have another question here. What should donors be prepared to do with regards to their policies, their MOUs potentially with NGOs, and maybe in terms of their own standard operating procedures? How should they start thinking about how they're going to operationalize their work with NGO partners?
So, so I think I assume there would be, in general, an approach to GDPR compliance. I'll just try to put it in the context of that. So I think what you would do is you would take the general approach to GDPR compliance that the company has implemented and adapt it for this particular scenario. So if the company as a general practice is, requiring any agreement with a third party to have data protection provisions, for example, then any MOU or agreement you might have with an NGO should include those kinds of provisions, probably adapted for this scenario. That maybe not the same thing, but adapted. So that would be certainly one thing you should be aware of. And the general practices about processing and handling of data that might go between the companies would have to be applied to any data you might get in connection with this kind of effort. So I know it's kind of high level, but it's hard to give very specifics because it'll largely be driven by the company's overall GDPR compliance structure, because you wouldn't want to go too far off what you're doing already. But the concept here is that whatever you're doing, generally speaking, in GDPR needs to be sort of implemented in an adapted way for this particular scenario.
Got it. Okay. We have another question here. Is there a difference if the donation is product or cash?
No.
Okay.
I mean, it has to do with what data is being transferred. The GDPR is implicated by the sort of the geographical location of the entity and or the data subject. Is it an EU-based data subject? And the kinds of data that's being collected or processed, and that's it. It doesn't really matter what kind of what kind of donation is occurring, unless, I guess the one thing, now thinking through what maybe this is really driving at is you may not have to worry about the beneficiary piece too much. If the donation is cash, you don't really need the beneficiary information, really, I don't think. So if you're donating to a LEAF organization and they use the donations to do something, buy medicines, and likely you're not going to require individual beneficiary data or medical data back. So the cash donation is less likely to require the exchange of detailed medical information, which is probably I think one of the biggest issues relating to these particular efforts.
Got it. Okay. One more question. In the case of adverse events, NGOs may need to report patient information to FDA. What are the implications, if any, for the NGO and or the donor if the beneficiary is an EU patient?
Yeah, so that has to do with the ultimate disclosure of data. And there is some language in the GDPR that allows the disclosures of data in certain situations that, for example, in order to comply with legal obligations or legal defense or claims. So, whether I would argue, although again, as this law has not yet taken effect and it's not written with FDA adverse event reporting in mind. But I would argue that that would fall within an exception, that it's necessary for the public interest, and therefore it's permitted to report that information to the FDA. But I don't think it's a simple, easy answer.
Mm-hmm.
And I think there'll be some clarification along the way.
Okay, great. Well, I have no more questions, although I thought those were a great set of questions. Again, thank you for your time, talent, and energy in spending time with PQMD and PQMD members and the COP community at large. We hope you've enjoyed, everyone, today's presentation. In the coming months, we'll be hosting more Pillar Talks, followed by online discussions on the community of practice, and we hope that you will join us. A calendar of events will be posted on the community of practice, again, cop.pqmd.org, and on the PQMD website, and be included in the newsletter as well. So enjoy the rest of your day and the upcoming holiday. Thank you, everyone, for joining. And please join me in thanking Scott and Kim Keller for their time. Thank you, Scott.
Thank you very much, everybody. Have a good day.
Thanks. Bye-bye.